Administrative decision makers, they don't have any inherent power like judges do. Their power comes from the enabling statute. So you have the statute, the regulations that are a little more detailed, made pursuant to a statute, and then even more detailed, we have the rules and any practice directions.
Conflicts go both ways. A lot of times people think of conflicts with clients. So I have one client and I'm checking their information against other clients I've had. But it also deals with you as a person. Maybe you were at a firm where you represented one party, and although you've left to go to a different firm, that firm is against the client from your previous firm. You may have a conflict there as well.
The document that does get a witness to court is a Form 16, and that is a subpoena to a witness. Always, always, always note that it is imperative for an individual to follow up. If one is evading services, so if they're not coming to the door, or they're not connecting with the officer in charge that may be reaching out to them, that is something that is an issue. So you always want to notify the witnesses that you may be calling that, hey, you want to ensure that you are following up and you are attending court because this is a court order.
The defendant's breach caused the plaintiff injury or loss would be the causation. So did the conduct of the defendant, which is in question, cause the injury or loss directly? Here the court uses the but-for test, and it is the principle that it is not just simply sufficient enough for the plaintiff to merely demonstrate that the defendant was negligent. It must also establish that the defendant's negligence was the actual cause of the injury.